So
This conference will now be recorded.
So good morning, everyone. This is Rebecca Smith-Aldridge from the Mid-Hudson Library System. We're here today for an overview of the Americans with Disabilities Act, very commonly called the ADA, for library facilities. We're happy to present this webinar this morning in partnership with the Northeast ADA Center. We're going to get an overview of the Americans with Disabilities Act with a particular focus on ADA Title II obligations for state and local government entities, which includes public libraries. Jennifer is going to discuss ADA priorities for physical accessibility and answer your questions. So as we go through the webinar today, you're welcome to put your questions in the chat box and I'll moderate those and Jennifer will answer them as we go through. If they end up going down a rabbit hole or getting too in the weeds, we'll save some of those more detailed things for later in the webinar, but do feel free to put your questions in the chat box throughout the webinar. Jennifer is an access specialist with the Northeast ADA Center, and the Northeast ADA Center has a pretty great goal, which is to educate and empower the diverse range of ADA stakeholders throughout New York, New Jersey, Puerto Rico, and the U.S. Virgin Islands to increase their knowledge of the ADA, to support stakeholders to include people with disabilities in local communities, and to implement the ADA in their own lives, workplaces, businesses, and communities. And we all know as public libraries, we're here for everyone, and that means people with differing abilities and access to our buildings. And a lot of us have challenging situations with more historic buildings. So this is a tough issue for a lot of people in our region. So I'm thrilled to be able to have an expert, which is Jennifer, to explain some of this stuff to us and answer our questions about this. Jennifer has worked in the accessibility field for over 19 years with a focus primarily on design and construction issues. She provides accessibility training for architects, code officials, and other stakeholders that are tailor-made for jurisdictions and include state-specific accessibility requirements. Jennifer also provides technical assistance to these individuals. So a long history of expertise on this topic. Jennifer, thank you so much for joining us today.
Thank you, Rebecca. It's great to be here. So thank you for extending the invitation. And thank you for everyone for joining today's webinar. And as Rebecca said, my intent today really is to provide you all with an overview of the Americans with Disabilities Act, or the ADA, as Rebecca said, and really focus in on those requirements that apply certainly to public library systems, but in addition to that, also to all state and local government entities. And we'll talk more about what that Title II, what that really means under the ADA, but that is my goal today, to give you an introduction to that. As Rebecca said, I am your presenter for the day. I work at the Northeast ADA Center, specifically within the what's known as the Yang Tan Institute on Employment and Disability, which is housed within the ILR school at Cornell University. So that is where I'm coming from. I'm happy to share, if Rebecca has not, I'm happy to make sure that all the attendees that would like a copy of the slides I'm using today, you can certainly have access to them. We can email you a PDF file of the slides. And I've included my direct contact information there. So should you have any follow-up questions after the webinar today, you know how to reach me. I provided both my direct office line as well as my direct email, as well as our website information. So please don't feel as though you have to have all of your questions answered today. It's very common that I hear from people that attend trainings or webinars a week, a month, or a year later, and I'm happy to answer any questions you have at any time. I did want to briefly just talk about the Northeast ADA Center and the work that we do. On the screen, you can see our toll-free technical assistance line, which really is a hallmark of the Northeast ADA Center. So this is a confidential technical assistance line that you can call Monday through Friday from 8:30 to 4:30. There is no charge, and we provide, as I said, confidential technical assistance and answer questions certainly about the Americans with Disabilities Act, but also on a broad range of other topics that are related to disability. So please do feel free to take advantage of our toll-free technical assistance line. We're here to help. In addition to operating that technical assistance line, we also provide training and consultation on topics related to disability and the Americans with Disabilities Act. Now, if you did have a question about the ADA or about disability in general, and you didn't want to call, you prefer to email us, you certainly can do that. And you can email us at northeastada@cornell.edu. And unlike some agencies that you might call, we actually answer the phone and we actually get back to you. And we pride ourselves on that, generally the same day. No more than 2 days will pass before you'll get a response from us. And usually it's either immediate or within an hour or so. So please do feel free to take advantage of that service that we offer. Because I work at Cornell University and the Northeast ADA Center is funded by a federal agency, I'm obligated to share our disclaimer slide that you see here. It's letting you know that our center is funded by the National Institute on Disability, Independent Living, and Rehabilitation Research. And we are funded, as I just said a moment ago, to provide training and information and technical assistance on the ADA. But I have to caution you that, I am not an attorney, and you should not construe this information provided today as legal advice. So in talking with Rebecca and preparing for today's session, we came up with this agenda that you see here. We thought we would start by really giving you, again, that broad overview of the law of the ADA, talking about where and when the law applies, as well as who enforces the various provisions within the ADA. We're also going to focus on the ADA definition of a person with a disability and go through so that everyone understands who is protected by this federal civil rights law. And then we'll jump into the more specific obligations that fall on state, local government, or public entities under Title II. And that includes discussion of what's known as program access, self-evaluation and transition planning, reasonable modifications and accommodations, and then effective communication. Along the way, I'm happy to answer any questions that you might have. As Rebecca said, if we get too many, I might say let's pause and wait until the end, but I'm happy to try to address them as we go. So that is our agenda for the next roughly hour and a half-ish. So let's jump right in and talk about the Americans with Disabilities Act. And I'm just going to try to answer this question. What is the ADA? Through that technical assistance line that I mentioned, we get calls from all kinds of stakeholders, Monday through Friday, and it's always amazing how many people this day and age really still just don't quite understand what the ADA is. People have a general understanding of it, but at its roots, most importantly, the ADA is a federal civil rights law. It was passed in 1990 by President George Bush, and it was amended in 2008, and those amendments really strengthened the law. It was not in any way weakened from its original state in 1990. It was really strengthened in 2008. The goal of the ADA is to achieve equal opportunity and equal access for people with disabilities. Not special treatment, but equal access and equal treatment for people with disabilities. So right now, hopefully you can all see this photograph that I'm sharing on the screen. And the question is posed, who benefits from ADA design standards? Here you can see a typical scenario that we see, every day. Front of an office building, there's, a ramped entrance going into the building. Prior to the passage of the ADA, a lot of buildings did not have ramped entrances. They probably only had steps. This day and age, many of us have become accustomed to seeing ramped entrances, so much so that many younger people in today's society probably don't remember a time when access wasn't so easy, whether you are an individual with a disability who perhaps uses a mobility device like a wheelchair, or someone who's doing your job. You work for a UPS and you're delivering packages, or your mom pushing a stroller. Certainly one of the benefits of the ADA to everyone has been this equal access and ease of access for everyone. But certainly the intent of the ADA, the reason ramps like this exist, is to protect the civil rights of people with disabilities. The side effect, again, has been that the ADA design standards have benefited many. And in fact, the ADA has really been, or was, I should say, the precursor to broader design concepts. I'm sure many of you have heard of universal design, designing environments to be accessible for all, not just for people with disabilities, but for everybody. And that same logic has even bled into the design of products, making sure things are designed so they work for people who perhaps are right-handed or left-handed. So taking this concept of accessibility a step further and introducing that concept of universal design. Now, on that technical assistance line, we also spend a lot of time educating people about what the ADA is not. It is a federal civil rights law, but the ADA is it's not an agency. It is certainly not a social service program. Many people sometimes confuse the ADA with other programs like Social Security disability, when there is no relationship at all between the Americans with Disabilities Act and that program. There is an ADA building in Washington, D.C. People will call us and say, you know, I have a complaint and I'm gonna call the ADA, when in fact you cannot call the ADA. The ADA is a federal, as I said, it's a civil rights law. You can't call it. So we spend a lot of time trying to educate people about what the ADA actually is. And this is a lot of the questions we get for me to explain to you what the ADA is not. Not an agency, not a social service program. And in addition to that, unfortunately, the ADA is not going to be the cure-all for every injustice that people with disabilities encounter. I certainly wish it could be, but the way the law is designed, it is not always going to be the answer to problems that people with disabilities face, which certainly are many. In some cases, the ADA absolutely can be of assistance, but unfortunately it does not apply in every situation. So with that, I can tell you where the ADA does apply and where it does protect the rights of people with disabilities. And the areas where the ADA applies are reflected in what are known as the 5 titles of the ADA. So we can kind of go through them here. And in red, I've indicated what federal agency enforces those specific provisions of the law. So the first title of the ADA applies to employment. And this is the portion of the law that prohibits disability discrimination throughout all of the employment processes. So if you are an individual with a disability and you are applying for a new job, or if you have a job and due to disability you need what's known as a reasonable accommodation, you have rights, and those rights are protected under Title I of the ADA. The way the ADA is designed from an enforcement perspective is through the filing of complaints. In the case of employment, if you are an individual with a disability and you feel as though you're being discriminated against based on disability, that complaint will be filed with the Equal Employment Opportunity Commission, or the EEOC. That is the federal agency that enforces all of the employment-related provisions of the ADA. So the EEOC has oversight and enforcement authority when we talk about employment. And this is why I said earlier, you can't call the ADA. And that's in fact because depending on what area of the law you're interested in, different federal agencies have enforcement authority. So that's Title I. It protects the rights of people with disabilities in employment. We'll move on to Title II, and I've inserted a red arrow there because Title II is what applies to state and local government entities. And we're going to talk in more detail about Title II in a few minutes, but certainly public libraries would very clearly fall under Title II of the law, which basically applies to anything you can think of that's funded somehow through your state, local, county tax dollars, those types of programs, including public transportation. And who enforces Title II? It's primarily the United States Department of Justice, or DOJ. And when we get into public transportation, then the U.S. Department of Transportation, or DOT, they have some enforcement authority in that area. But primarily it's the U.S. Department of Justice. Title III applies to what are known as places of public accommodation. And this is the portion of the ADA that requires accessibility in most places that are open to the public and in some way affect commerce. This includes things like restaurants and hotels, retail shops, places of business, movie theaters, bowling alleys. All of these things that are open to the public and affect commerce fall under Title III. And these provisions are also enforced by the United States Department of Justice. There are two exceptions, two entities, I should say, that really don't fall under the purview of the Americans with Disabilities Act. And they include religious organizations or affiliations, so places such as churches or synagogues or religious affiliated schools. They would not fall under the Americans with Disabilities Act because of the separation of church and state. And the other exception are what are known as true private clubs. And to be honest, those true private clubs that are exempt from the ADA are few and far between. These are clubs that are highly, highly selective of their membership. They generally have very high membership dues or fees. And they're clubs that fall under the exception under the Civil Rights Act of 1968 as well. So it's not as if you belong to a swim club in the summertime in your town and you pay a fee to join that club, that swim club is not exempt from the ADA. That's not the kind of true private club that falls under that exception of the law. And I should also mention, just since I brought it up, even though an entity like a church might be exempt from the ADA, in terms of physical accessibility, churches are still regulated by the Building Code of New York State. So under the Building Code, a church is viewed as a place of assembly. And as such, the Building Code will require basic accessibility. Things like ramps and accessible bathrooms. The Building Code will still require those features in a church or in a synagogue, but the ADA would not because of that separation of church and state. Moving on, so Title IV of the law applies to telecommunications, and this is the portion of the ADA that requires access, including telephone and communication systems for people with sensory disabilities. And there's some joint enforcement efforts under Title IV between the Federal Communications Commission, or the FCC, and the United States Department of Justice. So I can give you an example of something that falls under Title IV. Relay operator services. If you ever had to make a phone call to an individual who is deaf, obviously you don't talk on the telephone the way people traditionally speak. But if you are someone who's speaking, you may receive a telephone call from a relay operator who is communicating with an individual who is deaf, who can type their message on a text telephone. And then the relay operator can verbally repeat to the individual who is hearing on the other end of the line what they're saying. And then the hearing individual can speak back and the relay operator can text that message to the individual who is deaf. It's called a relay service. It's something that's mandated by Title IV of the ADA. In addition to that, certain television programming is required to have closed captioning to make it more accessible to people with disabilities. That's another thing that falls under Title IV of the ADA. And then Title V is what we refer to as miscellaneous provisions, one of which is very important. And Title V states that individuals with disabilities cannot be retaliated against for trying to have their rights under the ADA enforced. So those are the 5 titles of the ADA. So those are the areas where the ADA applies. As I said, it does not apply in every situation. It does not apply to every building or to every entity, but it certainly applies to many. Rebecca, you just let me know if we have any questions that come in, because I'm full screen. I can't see the questions. So if any come in, just feel free to let me know.
Okay, will do.
Thank you. So let's move on now and talk about the definition of a person with a disability, because that's who the ADA protects, people with disabilities. And I wanted to take a moment and focus in on the ADA definition of a person with a disability, because the ADA really uses a legal definition as opposed to a medical definition, which is different than some other laws that you might be familiar with. Such as Social Security disability uses a different definition. So let's talk about how the ADA defines this term. So it's what we call a three-prong definition, and we'll go through it and make sure everyone understands who's protected by this law. So the first prong of the definition says that the ADA protects the rights of people with disabilities, which includes people who have a physical or mental impairment that substantially limits one or more major life activities. I know that's not exactly the clearest definition, so let's kind of break it down a little bit. First thing I want to point out is that the ADA protects the rights of people with physical, which many people already knew, disabilities, but it also equally protects the rights of people with mental impairments. Sometimes that's an overlooked piece of the Americans with Disabilities Act, but certainly that is the intent of the law. So ADA protects the rights of people who have a physical or mental impairment, and that impairment must substantially limit one or more major life activities. So I'm going to go back to the screen in a second, but I want you all to think about, what do you think a major life activity might be? And I'm going to come back to this slide, but here are some examples of major life activities. And certainly there's more than what you see here. But things such as walking and seeing and hearing and speaking, sleeping, breathing, working, performing manual tasks. These are just some examples of major life activities. So to go back to that definition for a second, if you're somebody who has either a physical or mental impairment that substantially limits one or more major life activities, which could be walking or talking or eating or breathing or sleeping, then you're protected under the Americans with Disabilities Act. You do not have to register with any organization or association or with the Department of Justice. You don't get a wallet card, because again, this is a civil rights law, but you do have rights that are protected if you meet this first prong of that definition. Now, the second prong of the ADA definition of a person with a disability protects the rights of people who have a record of an impairment that substantially limits one or more major life activities. I can give you an example for somebody who might fall under this prong of the definition. This could be perhaps an individual who had cancer and they've recovered, their cancer is in remission, and they then go and apply for a position and they don't get the job. And the reason they don't get the job is because of their record of having cancer. In this instance, that individual has rights under the ADA, and they are protected under the law because they've been discriminated against based on that record of having an impairment that substantially limits one or more major life activities, even though they might not currently have that kind of impairment. And then the third prong of the ADA definition is that a person with a disability is protected under the ADA if they are regarded as having such an impairment. Regarded as is certainly one of the more confusing prongs of this definition, but you could potentially have a situation where an individual does not actually have a physical or mental impairment that substantially limits a major life activity, but they are regarded as such, or in essence, they are treated as such or discriminated against based on this assumption. That individual is protected under the ADA as well. So as an example, you might have an individual who perhaps was in a fire, and in this fire they sustained some scarring, maybe on their face, and they go and interview for a position, maybe as a hostess at a restaurant. And while they're qualified, they meet the essential duties of the job, they are well qualified for the position, but maybe the manager is worried that this individual's appearance due to the scarring on their face might be a little off-putting for other customers that come into the restaurant. That facial scarring might not actually substantially limit any major life activities of that individual, but they're regarded as such. They're regarded as having this disability, and in essence, that's why they don't get the job. So that individual has rights under the ADA as well. So they would be protected under the law. So the point of this definition of a person with a disability under the ADA is that it is intentionally broad. It is meant to include many. It is not the type of definition that is meant to be very laser focused in. The exact opposite, in fact, is true. It's meant to apply to many individuals with disabilities. We'll get calls from people that'll say, is cancer, is that an ADA protected disability? Or is diabetes? In most cases, yes, I would say that, but what you have to really look at is how that individual's physical or mental impairment substantially limits them and their major life activities. So there is no, black and white list of here's the disabilities that the ADA applies to for this reason, and that's because of this definition that we have here. So that is how the ADA defines a person with a disability. So ultimately, the light bulb moment, if you will, or the point of the ADA is that people with disabilities should be able to, obtain or enjoy the same goods. If you're a business, your goods, your services, your facilities, your privileges that are provided to other members of the public. And in doing this and providing these services, entities, whether you're a public or a private entity, this applies to both, you cannot discriminate on the basis of disability when carrying out your programs or your services, nor can you ask unnecessary questions about someone's disability or deny benefits or services or impose eligibility requirements that are intended to segregate individuals with disabilities. And you also cannot charge people with disabilities for the costs that are necessary to make maybe your facility more accessible, by removing barriers or, installing ramps or grab bars in the bathroom. You can't pass those costs along to people with disabilities, nor can you charge for things that might be necessary for effective communication, such as providing interpreter, sign language interpreter services. You cannot charge people with disabilities for those types of services. So this really is, this slide is brief, but I think it really speaks to the overall message of the ADA. No matter, as I said, whether you are a private business or a public library providing your services, this kind of speaks to the general message of the ADA. So a moment ago, I gave you that brief overview of the 5 titles of the law, but because we're speaking to a state and local government entity, public libraries, I thought we would now focus in a little bit more on Title II of the ADA and what Title II requires of public entities. So we'll start with some examples of, exactly who does this part of the law, Title II, apply to. So here's just some examples. Certainly Title II would apply to any of your city, state, or local county recreation agencies. So if you have a recreation department in your county or in your town, certainly the Title II of the ADA applies there. It also applies to your municipal buildings, your courthouses, any of your county or local government buildings and agencies. Absolutely, public schools fall under Title II of the ADA. So do places where you go and vote, your polling sites. Even if you have a situation where a polling site isn't always a polling site, it's normally a firehouse or it's normally a school, on election day, when it's used as a polling site, it falls under the ADA as well. Your public museums, certainly public libraries, and the ADA also applies to public transportation, so buses, as well as public transportation facilities, and even things like correctional facilities. Again, if you think of how things are funded, if there's a funding mechanism that involves state or local tax dollars, generally that's something that falls under Title II of the ADA. So the language that's used by the Department of Justice, remember that's who enforces most of the provisions that we're talking about today. The ADA regulations require that state and local governments ensure that all of their programs, activities, and services are accessible to people with disabilities. There is another law that many of you might be familiar with. It's called Section 504 of the Rehabilitation Act of 1973, which also mimics the ADA and says that recipients of federal funding cannot discriminate against people with disabilities. And again, it's been around since 1973, Section 504. And Section 504 explicitly applies, though, to people that receive federal financial assistance, whereas the ADA applies to anything funded with your state or local government finance. So sometimes people think the ADA only applies to federal funding, which clearly is not the case. The ADA does not apply there at all. However, that other law, Section 504 of the Rehab Act, does apply. So you could, if you're a city that gets funding from the federal government in some way, then you have to comply with both Title II of the ADA as well as Section 504 of the Rehab Act. It's not as if one of these laws trumps the other. They just kind of both apply. And when we talk about serving people with disabilities, they very much both require, you almost get to the same point of making sure your services and your programs are accessible to people with disabilities. So when we think about Title II and local government and all of your programs and your agencies and your services that you provide, the ADA is not just about building accessibility, meaning physical accessibility. What the ADA requires of public entities is that you have looked at all of your programs and your services to determine, are they being delivered in an accessible manner? You may have older buildings in your local government, in your town, in your city, and that's not a violation of the ADA. What would be a violation of the ADA is if you were offering all of your programs and services in that older building that's not accessible to people with disabilities. So Title II addresses this by requiring what's known as program accessibility, ensuring that your programs are accessible to people with disabilities. What this means is that if you have a town with many older buildings, perhaps even historic buildings, it's not a violation of the ADA that you have, those buildings. Congress, when they passed the ADA in 1990, certainly recognized that throughout this country there are many older buildings, particularly local government buildings, that were already in place, that were already built, and that might not be accessible to people with disabilities. So because of that, Congress came up with this concept of program accessibility, which says you don't necessarily have to go into all of those buildings that were built pre-ADA that might not be physically accessible and make them fully accessible. But what you do have to do is make sure that any programs or activities you're offering inside those inaccessible buildings, those programs or activities have to be made accessible in some other way. And that's why it's known as program access. So some examples are relocating your services to another accessible part of the same building or site. Perhaps delivering your services at alternate sites. If you have an older building that has 2 floors, but there is no elevator to get to the 2nd floor, then maybe you're hosting your public meetings on the 1st floor, assuming that's accessible to people with disabilities. So it's really about modifying your policies, how things are normally done, to make sure that you're, when carrying out those programs, you're not excluding people with disabilities. And it's also important that you do try to give priority to the most integrated setting appropriate, so that you are not segregating people with disabilities unnecessarily. So Title II says that you have to make your programs, your services, your activities accessible. So what does that mean? What are programs, services, and activities? Well, for Title II, for public entities, what this means is a program is something that's defined as an activity that's undertaken by a department that somehow benefits the public or provides opportunities or activities to one or more members of the public. Certainly going to your library, participating in programs that are hosted at a library system would clearly be considered a program under Title II of the ADA. And here's a concrete example that we can look at of one program that would have to comply with the ADA. Let's say you have county board meetings. Under the ADA, if you were trying to evaluate the accessibility of these county board meetings, you would first have to look at the facts of these meetings. So let's assume that these meetings are held, to conduct county business, to hear from residents of the county. They are held in person. They're held, on the third Wednesday of every month. So they're on a regular basis, and sometimes they're responsive to urgent situations. In determining how accessible these meetings are, you'd want to evaluate all these types of meetings that you have and seeing if there are any barriers to people with disabilities from attending these meetings. And those barriers might be physical barriers, and they also might be more related to things like effective communication. You want to determine, are those meetings overall accessible to people with disabilities? So the other thing I wanted to point out is that under Title II, there are some very specific, what are known as administrative requirements for public entities, things that are required, and some of these, frankly, have been required for quite some time, in order to make sure that the public entity or agency is complying with the ADA. So the first thing that's required is designating a responsible employee, someone who has the authority necessary to make decisions and take action. Usually this is, referred to as the ADA coordinator. Some people use different terms. It doesn't really matter what term is that you use, but it's essentially a point person who is there to try to make sure that whether it's a town, a city, or a county, and you can have ADA coordinators at each of those levels, by the way, but this is the individual who you go to if you are an individual with a disability and you have questions or concerns. The second administrative requirement under the ADA is that you have established a grievance procedure. And this is a mechanism for people with disabilities who might have complaints about accessibility or ADA compliance, that there is a well-publicized and publicly available procedure of who to contact, which is usually the ADA coordinator, to express those grievances. The third administrative requirement is that you provide a notice to the public, and this is your public statement of your commitment to and compliance with the ADA. Generally, this is something that's, it's printed, it's available at town hall, certainly at libraries, it's usually on your website. So something to let the public know that you do indeed intend to comply with the ADA. Now, this is the fourth administrative requirement is the conducting of a self-evaluation. Now, when the ADA was passed in 1990, this was supposed to have been completed by July 26th of 1993. And I can't tell you how many cities and towns and counties across the country, when they see this slide, they're like, oh my gosh, we didn't do that. A lot of people have not. So first of all, please don't be alarmed. And it's very possible that a self-evaluation was done back in 1993, but sometimes people just aren't aware of where it is or what's been done with it. So the self-evaluation in any case is essentially an assessment of all of the services that you provide as a public entity, taking a look at them like those county board meetings that we saw a moment ago, and determining if there's any barriers for people with disabilities. You might determine that at that county board meeting that you were holding on the second floor of a building with no elevator, that's a barrier for people with disabilities. So you determined that barrier when you did your self-evaluation, and the fix was to move those public meetings to the first floor or to another building that did have an elevator if you were using a second floor. The point of this self-evaluation, though, is that by doing this assessment, you discover where those problems lie and identify those barriers. So this initially should have been done, as I said, back in the early 1990s, required of all public entities, and had to be kept on file for 3 years. For the fifth and final administrative requirement is the development of what's known as a transition plan. And a transition plan is essentially a plan that identifies where there's a need for physical accessibility for renovations, because there's no other way to make a particular program, service, or activity accessible. So if there's a situation where you can't relocate something, maybe you only have one building in your small town where all of your public meetings are held. And if that one building has barriers to accessibility that are physical in nature, you're going to have to make it accessible. And that would then become a part of your transition plan, because the transition plan addresses all of those barriers that are architectural in nature. And Congress recognized that, just as Rome wasn't built in a day, oftentimes it's not possible to eliminate all physical barriers to accessibility in a day. It's going to require a plan. And a transition plan is exactly what that is. It's a plan that identifies those architectural barriers, and then develops a time frame by which they will be completed. And it also involves some hard conversations about where do we start? How do we prioritize what should be made accessible first? And that's where receiving input from the public, particularly from members of the community with disabilities, is very helpful in sitting down and determining, here's the money we have to spend this year, here's the money we have to spend next year, and developing that plan of what barriers to address and when, and then implementing it. That is the fifth, and this is the administrative requirement that most people are most familiar with, I should say, under Title II of the ADA. Again, this should have been completed in 1992 with the barriers removed by 1995, but there are countless public entities throughout the country that are still today working their way through their transition plan as we speak. Does anyone have any questions about, because those are the 5 administrative requirements for public entities, and I just wanted to pause for a second and see if anyone had any questions that I can answer about those.
Hi, Jennifer. We've got a question from Brian in Pauling. He describes his library as a quasi-government entity. And we can talk a little bit more about that if you would like, but he asks, is each library required to have its own ADA coordinator and grievance procedure, or are they only required to comply with directives issued by the ADA coordinator designated by their municipality?
Thank you, Rebecca. That's a great question. The ADA does not require that every single library has an ADA coordinator. Nothing would prevent, however, if somebody wanted to have one person at each site, kind of wear that hat for their specific facility, nothing would prevent that either. So no, essentially, if you have one central ADA coordinator, that is fine. These administrative requirements only require that you have that one public entity, but particularly in large cities, like I just did a training 2 weeks ago for New York City, and they have taken the approach that every single city agency has an ADA coordinator that then reports to the mayor's office for people with disabilities and other agencies. So they have hundreds and hundreds of ADA coordinators. Depending on the size of your organization, you might not need one at every single branch.
I think that's a good distinction, that most of our libraries are standalone units that are separate legal entities. We only have 4 libraries that actually have multiple branches. So it sounds like you're saying that if you are a library with multiple branches, you could just have one ADA coordinator that covers the whole organization. But if you're a standalone library, separate legal entity, you have one building, you have one ADA coordinator.
That sounds like that would be a good approach, yes.
Okay.
Were there any other questions, Rebecca?
That's the only one I see so far.
Okay, thank you. Okay, so that is the transition plan. So, and there is some language about if you have less than 50 employees under the ADA, then you're not required to appoint that official, ADA coordinator or establish a grievance procedure. However, it's still a good idea. You're still strongly encouraged to do so because you still have to comply with the ADA. You're not exempt from complying with everything I just talked about. You just don't have to go through those 2 official steps, which are actually helpful in meeting your ADA obligations. So this is just another slide. It's going to seem a little repetitive, but it's important. So I just wanted to review again the non-discrimination provisions of Title II. Again, which is that people with disabilities have an equal opportunity to benefit from everything that you're doing, your programs, your services. Also that you're willing to, as a public entity, reasonably modify your policies, your practices, and your procedures in terms of serving people, particularly with sensory disabilities, that you're achieving what's known as effective communication by offering things like auxiliary aids or services. And we'll talk more about that in a minute too. Taking a look at your eligibility criteria. Certain programs this day and age we're accustomed to being asked to show our driver's license for, when applying for certain programs or activities. Being willing to modify that policy, some people based on their disability can't drive and they don't have a driver's license. So being willing to accept other forms of valid ID instead of a driver's license is just one example of being willing to reasonably modify your eligibility criteria that might screen out people with disabilities. Same thing applies if you're issuing licensings or exams, that you're making sure you're doing so in accessible locations, that you have alternate formats, things like large print available if necessary, and that you're not charging people with disabilities for those alternate formats, or if they are using a service animal, which we'll talk more about in a moment. And then also on not just the ADA doesn't apply just to the public-facing side of what you do, but also internally, making sure that you're complying with those employment provisions I talked about earlier under Title I of the ADA, making sure that you're also accommodating your employees who may have disabilities as well. So here's just some examples of reasonable accommodations and, kind of how the message of the ADA is that you take a look at how things are typically done and modify them slightly if doing so is what allows someone with a disability to benefit from your services. So that might mean just helping someone fill out a library card application. Might not be something you normally do, but in the case of somebody with a disability, maybe this is a way that you can provide a reasonable accommodation. Reaching materials that are on higher shelves that somebody might not be able to reach themselves, and providing things like handouts in large print, generally blowing things up to, doesn't have to be 18 font, just as an example, providing handouts in that large print. And these, by the way, I'm sure are things that many of you probably do all the time already. I just wanted to point these out as these are just some examples. When you hear that term reasonable accommodation, it really can be as simple as what you see here. Things that you're already doing. So you also under the ADA are expected to modify, as I said, how things are typically done, your typical policies, practices, and procedures so that people with disabilities can benefit from your programming. There is language in the ADA, however, that says that you are not, as a public entity, required to reasonably modify your policies, your practices, and procedures if doing so would fundamentally alter the program. And a fundamental alteration is a change that is so significant that it alters the essential nature of what you're doing, of the program that you're offering. And this applies to both the application requirements as well as to the program, service, or activity itself. So there is language that, there might be some requests for reasonable modifications that cannot be accommodated but again, they would have to rise to the level of being a fundamental alteration, which again is a change that is going to be severely significant, and is really going to alter the sense of the primary mission, I should say, of the program. One example of a reasonable modification of your policy is service animals. Most places have, no pets allowed types of policies, but I'm sure as many of you are aware, the ADA says that people with disabilities have to be permitted into public entities as well as to private public accommodation areas if they are accompanied by a service animal. So allowing service animals is a reasonable modification of a no pets policy under the ADA. And the ADA defines service animals now as dogs, or in some cases miniature horses, that are trained to do work or perform tasks to assist people with disabilities. If somebody comes into your library, for instance, with a service animal, there are only 2 questions that can be asked of that individual, and they're shown here. One is this service animal required because of a disability? And what work or task has the animal been trained to perform? You cannot ask that individual to have the dog, you can't say, let me see that task, let me see what they've been trained to do. These really are the only 2 questions that you are permitted to ask. And service animals are required to be under control of their handler. They cannot be, certainly not running around the library or barking or being disruptive. They have to be, like, as I said, under the control of their handler. But these are the only 2 questions that can be asked. And I'm only even mentioning this because I know service animals is probably the hottest topic right now. We get so many questions on this topic, and if this is something you want to learn more about, you can always call our technical assistance line. We're happy to talk to you or send you fact sheets on this topic, because I know it is very much a hot button issue. I also mentioned it because it is, again, an example of a reasonable modification of your policy, which again might be no pets allowed, but service animals are not pets. They are permitted under the ADA. Now, in terms of physical accessibility, I touched on this earlier, but I wanted to circle back to it because I know a lot of libraries are older. Many public libraries in this country are housed in older buildings. So I wanted to kind of talk about what the ADA says in terms of physical access. So remember, under program accessibility, the ADA essentially says that before you go and look at every single building you have in your inventory, for any town USA, what you really should be looking at are what programs or where are your public agencies located at, and the services that you're providing, are those accessible to people with disabilities, and can they be relocated to other sites where there are physical barriers? This all assumes that these existing facilities, that means it was built prior to 1992. Under the ADA, anything that was built after 1992 or anything that was altered after 1992 had to be accessible, should be accessible. That is the assumption that I'm working under here, just to be clear. So an existing facility is something that was built prior to 1992. So how do you determine what's that benchmark for accessible? What does that mean under the ADA? Well, currently that benchmark is a standard known as the 2010 ADA Standards for Design. And these standards went into effect on March 15th of 2012. Prior to March 15th of 2012, between that date of 1992 that I mentioned and 2012, there were still ADA obligations in place. So anything built after 1992 had to comply with ADA, just with the older ADA standards. I want to point out to you that what changed in 2012 was, of course, the ADA standards were updated, made more current, and certainly fell more in line with what many building codes throughout the country were requiring in terms of accessibility. But in addition to that, the newer ADA standards also required accessibility in a number of areas that previously weren't addressed under the ADA standards. And they include things like swimming pools, boating facilities, fishing piers, golf courses, miniature golf courses, gyms, play areas such as playgrounds, and team or player seating areas. So now we have specific accessibility requirements for these features, many of which are important for towns and municipalities to be aware of, particularly things like swimming pools, in this area of the country, boating facilities and fishing piers, and of course, playgrounds. So we now do have specific access requirements for those types of areas. And the 2010 ADA standards for design apply to any of those entities that fall under those 5 titles of the ADA that I mentioned earlier. So certainly state and local government buildings, your places of public accommodation, remember that includes offices, businesses, retail, restaurants, as well as commercial facilities and, of course, transportation facilities. If you're interested in accessing the 2010 ADA standards for design, they're available online at ada.gov. You certainly can. They're publicly available. And if you have specific questions about them, you can also call us or call me directly. I'm happy to answer any questions you have. But the basic elements when we think of physical accessibility kind of follow this path that you see bullet pointed here on this slide. It may include assessing, can people with disabilities, and we'll use a library as an example, can they get to our front door from our parking area, if you have one, from public transportation? So if there is a bus stop that serves your library, is there a way for people with disabilities to get from that site arrival point to your entrance? You also want to look at the path of travel that's used, to get to that entrance. If there is a curb, chances are, people need a curb cut to get up onto the sidewalk. Are there, sidewalks that, are in good shape, that aren't in disrepair with a lot of cracks that might be troublesome for people with disabilities? Is your entrance accessible? Do you have, clear width at the doors? And is the primary function area accessible? The ADA really focuses in on every particular building when we think about physical access and looking at what is the purpose of that building? What is the primary function of that building? In the case of a library, you might actually have several primary function areas, but certainly it's critical to make sure that that reason that building exists, the reason people go there, that area is accessible. And then you also want to look at things like, of course, toilet rooms, are they accessible? Drinking fountains. The ADA doesn't say you have to have drinking fountains. It just says if you provide them, they have to be accessible. And public telephones, again, this is something that kind of just shows the age of the law going back to 1990. If you provide public telephones, you have to provide accessible public telephones. So as I said a moment ago, libraries can actually have multiple primary function areas. So you want to think about how people use the space and is each of those unique areas accessible? So in a library, this might include things such as study areas, clearance between stacks, desks, book depositories, if you offer computers or meeting rooms. These are all really primary function areas of libraries that you want to make sure are accessible to people with disabilities. And if you were interested in doing an assessment of your facility and seeing if there are any barriers, this is a wonderful resource that you can download free of charge. The website to do so is called adachecklist.org. It's a very well done checklist that will walk you through doing an assessment of your facility, from the front door throughout the space to your primary function areas to the bathrooms. So it really is an excellent resource that I would highly recommend. And if in doing this assessment, if you choose to, and you have questions, you can always call us at the Northeast ADA Center and we can answer any questions that you might have about it. Rebecca, before I continue on, have there been any more questions?
Nope, none have come through yet.
Okay, all right. So I am going to talk about some of the other areas where Title II of the ADA requires access for people with disabilities. And one of them is one of those areas that you should consider are effective written communication. So this includes looking at the materials that you might distribute or post for the public to view, making it available in alternate formats. So if you're having a public meeting, having an advance notice certainly is going to be very useful in making sure that you can meet the needs of people with disabilities who may need services such as a sign language interpreter or materials in large print. So certainly putting that notice out there so that you can say we need to know by XYZ date if you require materials in alternate formats will give you, the public entity, the time you need to provide those alternate format materials. And then making these types of notices available wherever you publicly display information for the public, including your website, making sure that people with disabilities are aware of how to request effective communication. Some other highlights or things to consider for public entities are, your policy for sign language interpreters. Again, it is absolutely fine to require advance notice for things like interpreters. As I said, you cannot charge people with disabilities for interpreters. You cannot ask them to bring their spouse or their family member or their friend to interpret for them. So if someone asks for an interpreter, unless it's an undue burden to do so, which is extremely rare, you must provide that service, that interpreter service. So putting meeting notices out and saying we need to know 24, 48, 72 hours in advance, whatever works for you, will give you the time you need to arrange for that kind of accommodation. And making sure that the interpreters you're providing, that they are licensed and capable of providing those services. Most public entities communicate with the public, by telephone. So you want to make sure that you're providing effective telephone communication by accepting calls from that relay service that I mentioned earlier. So whether you communicate with a relay operator, somebody who is using a TTY, which is a text telephone. If you have public telephones at your site, remember at least one of those is going to have to be accessible to people with disabilities. Again, you don't have to have public telephones, but if you do, one has to be accessible. And even if you have a policy that routinely allows members of the public to use other phones, the front desk or staff phones, you have to then make sure that there's a way to make sure that that policy is equal for people with disabilities, that they can also use those front desk or staff phones. You also want to look at your electronic communication. So this involves really thinking about how do you communicate what you're doing, the services that you're providing to the public. Everyone's familiar with, email, of course, and website communication. So it's important that you are aware of how to make your website and your email communications or PDF documents, taking a look at how to make sure that those are accessible for people with disabilities. And if you have a question about that, again, you can always call us at the ADA Center. We can certainly be of assistance there. So why is ADA compliance important? I just tried to bullet point a few things here. Well, first of all, I hate to sound all doom and gloom, but it is the law, right? So it is a federal civil rights law. But in addition to that, complying with ADA really allows you to meet the needs of a growing and certainly aging population. It's no secret that many of us age into disability. And some of those things like materials in large print and providing effective communication are really going to become important to many of us as we age. ADA compliance also allows you to achieve your public entity's goal of making sure that your programs and services are accessible to citizens as well as to visitors. By complying with the ADA, you can provide equal access to people with disabilities that want to take advantage of your facilities and your services. Also, you can educate and empower government personnel about the importance of providing access. So it really is, from several angles, a good idea to comply with the ADA, not just because it's the law, but because of how it benefits the people that you serve. I've assembled some resources. These are the ones that I thought would be of most interest to some of you. And again, you'll receive a PDF copy of these slides. But if you have additional questions on topics that aren't addressed in this resources list, just let me know. I'm happy to help you. But the first one here is the ADA Title II Action Guide, which is wonderful. If you have specific questions about those 5 administrative requirements, for instance, if you're thinking, I don't have a grievance procedure or I don't have a public notice about the ADA, if you go to that ADA action guide, they have sample documents there. So you can take a look at and even download it and make it work to meet your organization's needs, a grievance procedure or a public notice. So that's a very good resource. If you have questions specifically about service animals, there's a very good fact sheet I referred you to, as well as some information on website accessibility, because that is another hot button issue currently. And then just some more information for state and local governments on general ADA obligations. That's the primer for state and local governments. So thank you very much for your time. Thank you for attending. I'm happy to answer questions if anybody has any for me. And I guess, Rebecca, I'll pass it back to you and see if there are any.
Sure. Jennifer, I got to thank you so much. This was so clear and concise and to the point, and it answered the questions we frequently get here at the system from our member libraries on the various topics you covered today. I think the fact that we don't see many questions coming through chat speaks to what a good job you did today of helping us understand the finer points of the law and how we can best serve our public in as accessible a way as possible. So thank you very much.
Oh, thank you. I appreciate that.
All right. So as Jennifer made very clear, you know exactly how to get in touch with the ADA Center. If you have further questions, we'll make sure you have a PDF of the slides pretty quickly after this workshop wraps up here this morning. So you'll have that contact information and all the fantastic information Jennifer provided. We just want to again say thank you to Jennifer for providing this webinar this morning. I think it was exactly what I know our members were looking for. So again, Jennifer, thank you so much.
Oh, thank you. I appreciate that, Rebecca.